So before we get into any sort of technical questions, could you just tell us what exactly Byzantine law is, and like when do we think that it begins and ends? What is it as a corpus?
Byzantine law. I think this is something that you've addressed in more podcasts about the word Byzantine, because it begins with the word Byzantine, and that's a term, that's a fake term or a made-up term. So Byzantine law doesn't really exist as such a
Yeah,
term.
yeah.
Byzantine law is actually the law of the Eastern Roman Empire. And if we want to define it in a simple way, I think we can say that Byzantine law is a Roman law, but then in Greek. At least this is how it began.
Hmm.
Um, that's a definition.
Now,
So,
the
yeah.
Roman law had been appearing in Greek, for example, in Greek translations of Roman statutes and so on in the East, which we have in inscriptions from like the Republican period, right? So there's like a long period when Roman law is learning to operate in Greek and when the Eastern provinces are learning to live by Roman laws. And by the time Justinian kind of changes the language, it's not like a really revolutionary change, right?
Well, um, perhaps this is has to do with when does it actually start? You're right in saying that. Well, first of all, it's always tricky when you put a timeline or borders, and we
Mm,
historians love to do that. That's also tricky sometimes. But if you really want to draw a line, I think it's fair enough to say that Byzantine law begins with Justinian, and I can explain why. Um, but it has to do with his legislation. So Justinian, as most of your listeners would know, well, he was an emperor in the 6th century, and he issued very important legislation consisting of 4 parts. And he codified Roman law, you could say, and most of this legislation was issued in Latin. And that was a bit of a problem in this period because most of the people in the Eastern Roman Empire, Justinian was an emperor in the East, were Greek speaking. So Greek was the dominant language. So there you had this majestic legislation of Justinian. He was very proud about it. But people couldn't understand it. So what happened was, at that time, shortly after the promulgation of Justinian's legislation, uh, jurists, in fact, the law professors at the time of Justinian started to make Greek versions of the different parts of Justinian's legislation in Greek. So they made Greek commentaries, Greek adaptations, Greek versions of all of the parts. And this transition from Latin into Greek marks the beginning of Byzantine law, you could say. This doesn't mean, you're right, this doesn't mean that Greek wasn't used before in legal circles. I mean, one of our Roman jurists, Modestinus, he was one of the great Roman jurists who lived in the middle of the 3rd century AD. He wrote a lot in Greek.
hmm.
So, but if you really want to draw a line, this transition from Latin into Greek by the law professors at the time of Justinian, they were called, by the way, antecessors. Antecessor is a name to describe the law professors at the time of Justinian. And I think this is also logical. If you want to teach a text that's in another language, the first thing you do is you translate it in your own language.
Mm-hmm.
Or in any case, and if you start to translate, you interpret the text. So that's what I mean. This transition from Latin to Greek marks the beginning of Byzantine law.
Right.
And this is something that a modern scholar, Bernard Stolter, has written several articles on this topic. Stolte is emeritus professor of Byzantine law at the University of Groningen, where he speaks about this beginning of Byzantine law, the birth.
Yeah.
And I would say that these law professors who started writing the Greek summaries and the Greek comments, I think you can call them the godfathers of Byzantine law.
Right. Right. Because if I understand it correctly, the translations that they made or renditions,
Yeah.
yeah, they're
They're
not
not
exactly,
translations. Yeah,
yeah.
they're adaptations, you would say. Yeah.
Yes, because they preserve a lot of the Latin vocabulary, even in Greek. In fact, I just got here. Have you seen this? Eleanor Dickey's Latin Loanwords in Ancient Greek.
Not yet.
It just came out. It's like 800 pages, and it's basically a dictionary of Latin
Yeah.
terms in Greek in this period. A lot of them are Latin. I mean, law. So anyway.
Oh, yes, and not just in this period,
Yeah,
also later on, and we'll see that.
exactly. So if I understand it correctly, those translations that they made later were the basis, like the textual basis for the Basilica, which were issued like around 900 and were like the standard later version of Roman law in Greek.
Exactly.
Right?
Yeah, exactly. The Basilica was issued, as you said, later on, so around 900. And if you want to define it again in a brief way, you would say it's Justinianic law, but then in Greek. Because
Right.
by then you had all these different versions of different parts of Justinian's legislation. I didn't mention the parts. Should I mention them? I don't know.
You mean the book,
The
the different?
codex, the digest, the institutes, and the novels.
Yeah.
The novels were in Greek, by the way, but the rest was in Latin for the greatest part. So by the time of this Macedonian dynasty, you had all these Greek versions of different parts of Justinian's legislation. So they thought it's good to have one big legal compilation that would, how do you say, encapsulate the whole of Justinianic legislation, but then in Greek.
Mm-hmm.
And they used, as you said, as a base, writings from the antecessors for a big part. Yeah.
Yeah, and in a certain sense, Justinian's legal team is also doing something like that. And this is often, like, I find that classical historians and scholars who work on ancient Roman law often don't appreciate or don't want to always come to grips with the fact that, like, often what we call Roman law is what Justinian's team said it was. And they're compiling, they're abridging, they're editing, and I think they left out like whole categories of Roman law that were simply no longer relevant in the 6th century AD. For example, like just the other day, I was reading a discussion of how Roman law and local Greek law interfaced in the eastern provinces, like before the Antonine decree, in 212 that gave Roman citizenship to everybody, made Roman law sort of applicable to everybody. And all of those regulations about how these two systems are supposed to mesh are just kind of absent from the digest because they were just no longer relevant by the 6th century. And
yes.
yeah.
And I think also Justinian's goal was also to make a codification. So the digest is a codification, which means that it is exclusive. So he because we speak about the digest, I think it's good to know what that is, because I think that is the most important work from Justinian's legislation as far as the history of European private law is concerned.
Yeah.
Because the digest consists of fragments of the opinions of the best Roman jurists who had lived mostly in the 2nd and 3rd century AD.
Yeah.
So all this knowledge was put into this book. It's an enormous book. It's, to give you an idea, it's 1.5 times the Bible, and it's considered one law. It has the status of one law. It's one law. So, and if in fact Justinian says he speaks through the mouth of the Roman jurists.
Yes.
Yeah.
Yes, it's extraordinary the way in which these very, very large texts could be issued as single laws, which is a tradition that continued. So
and Justinian spoke about that. He said that there are no contradictions to be found in this, and he said if you find one, think again.
Yes.
So at that time, he believed that there was one law that could be used for. You could use it everywhere.
So there's this paradoxical situation where, Byzantine law in quotation marks begins at this point, but in a certain sense, so does Roman law, like classical Roman law, because that's our main source for it. Like, obviously, we can reconstruct its history before that, and there are inscriptions and papyri and texts that refer to laws that don't exist and so on. But it's fair to say that Justinian's corpus is also the main source for the study of Roman law. And So these two fields are kind of conjoined in that way. And yet I have the sense that ancient Roman law has received a considerable degree of scholarly attention, and Byzantine law has not. So what explains that imbalance? So that the Latin material leading down to Justinian has been studied very, very much. In fact, it's central to the legal traditions of many modern countries. But the Greek version of the same body of law is relegated to very small circles of Byzantine specialists.
Yes. Well, I think there's a short answer and a longer answer to this. The short answer is that, well, Byzantine law is in Greek, so you have less scholars who know Greek. Most of them know Latin. But the long answer is that most of the modern scholars are interested in Roman law. Roman law is the base, and I'm simplifying here things, is the base of most civil codes in Europe. The Roman jurists had discussed many legal questions and had come up with many solutions. And I have to explain here that the legal questions remain always the same. The society changes, and of course, it's a different society now. I mean, the concept of family is very different in Roman times than now. But the legal questions, I speak about the legal questions. How do you become an owner? How do you lose ownership? What happens if you buy something and it has a defect? All these legal questions were explained, discussed in detail by the Roman jurists. So, and they still have answers to contemporary legal problems. And again, I'm simplifying things, and I'm running through the history, but the core of most civil codes is based on Roman law. So Roman law, it's still in use, and it's still, people use it also to compare different legal systems. And this explains why people are interested in Justinian's legislation, because as we said, it codified Roman law. And you're right in this, the Roman law we know comes most of it from the texts of Justinian. This is how it's being preserved for a big part. So by studying this early, well, Byzantine law, now it's the term,
right.
Romanists have an interest in this because they can learn more about the actual Roman law, but they're not interested in what happened after. I think, again, it has to do with the bad reputation also of the word Byzantine. Like, Byzantine law is considered by many as a decadent, bad echo of Roman law, which is not always the case, I think. And what I find personally, well, frustrating as a legal historian, now frustrating is a big word, but we have a lot of books on European legal history, and they all discuss, well, they all have to refer to Justinian because it goes back to Roman law and his legislation. But in the West, there was a gap between the 6th century and the 11th century. Roman law was forgotten, more or less. And when I speak of Roman law, I mean the digest, which, as I explained, was the most sophisticated text because it consisted of the fragments of the opinions of Roman jurists. So this was forgotten in the West. And suddenly, in the end of the 11th century, beginning of the 12th, you have a rediscovery of Roman law in Italy, in Bologna. And then Roman law is spread throughout Europe, more or less. But in the East, there was no gap. In the East, we talked about the law professors at the time of Justinian who adapted the text and brought Greek versions. And so Roman law became Byzantine, you would say, and continued. So you have a continuation in the East, and that's not being even mentioned in modern books. So that's something that, that I think it's not fair, because there's a lot. Well, you can use Byzantine law also to explain Roman law, but there's also a big development of Byzantine law as well that's been left out.
Yes, and you're exactly right. I think the term Byzantine is off-putting, especially because it suggests that something is convoluted, complicated, and sort of decadent. But there's a paradoxical way in which our concept of Byzantium has been shaped by these legal priorities, and I've kind of been researching that on the side in the following way. Because Justinian became so central to the legal traditions in Western Europe after 1100, when Western writers were trying to decide where Rome ends and Byzantium begins, there's this very prominent tradition that puts that break at Justinian and does so for the sole reason of keeping the corpus for the Roman / Latin / Western tradition. And everything after that is Byzantine. We don't care about it, right? As opposed to, say, putting it at Constantinople, the foundation of Constantinople and Constantine, whatever, because then that would put the corpus squarely in Byzantine territory, which is... So you see these efforts, and these start in the Middle Ages, as I've seen it in the 12th century, where they're saying, well, the Romans lasted until Justinian, and after that, it's the Greeks.
Yeah.
And it's just for that reason.
No, that's true. Yeah. And in fact, you see that in the Byzantine legal tradition, the rediscovery of Roman law in the West began at the end of 11th, beginning 12th century. In the same period, there is a small revival of legal studies in Constantinople as well. But there are also, we refer to the Basilica. The Basilica, we said it's a legal compilation it was issued around 900, and it's a massive legal compilation that reflects Justinianic law, but then in Greek. Except from the Basilica text, later you have Basilica Scholia, so comments on the Basilica, which are distinguished in two categories: the old, which date from the antecessors, the law professors at the time of Justinian, and were added to the text of the Basilica because they could help the interpretation of the text, and the new Basilica Scholia, and that's where I'm coming to, which are comments made by Byzantine jurists of the 11th and 12th century on the Corpus Juris, on Justinian's legislation. So there you can have a very nice comparison between the comments, the glosse, we say, of the medieval civilians in the West with the corresponding or relevant scholia or comments of the 11th, 12th century Byzantine jurists on the same texts. And these Byzantine jurists are closer to the texts, not only geographically, as a colleague of mine has said, Brandsma, but also as content, because they have been faithful. The Roman law, again, was never interrupted in the East.
Yeah. And those scholia, by the way, contain really fascinating observations. They're like little gems in there. I sometimes... I mean, so this is a very big edition of the Basilica. It's many, many volumes, the text itself, the scholia itself. So it's not always easy to go looking for the scholia all the time. But sometimes when I look at the Greek version of one of the digest entries, I go look at the scholia, just kind of see what sort of opinions I'll find. And some of them are very interesting. So let's get to the question of why this field is considered sort of hard and esoteric and kind of difficult to... By the way, I don't find the Greek to be especially difficult. It's not. It's certainly not compared to orations. I mean, Byzantine orations can be really, tough nuts to crack. But the legal texts, I generally find them straightforward. But why does it have this reputation of being this very obscure and difficult field to enter?
Well, you have to know Greek, as you said, but
if
the Greek is not a problem, well, the problem is it's also legal Greek. So I think we said earlier on that legal terms remained in Latin. You said in the 6th century, but actually even in the 11th, 12th century, the legal jargon, how do you call it? It survived in Latin for many, many centuries. And when I say Latin, either in Latin letters or transliterated in Greek letters, but then a Latin term. So you need to know Roman law. So perhaps you can read the Latin, but I'm not sure if you could understand. You can read the Greek, but it's not always easy to understand what it says because it's technical Greek. Because you need the legal terminology. So you need a background of Roman law when you see a term in transliterated Greek letters. And another thing, Byzantine legal texts have many layers. I refer to the Basilica. The Basilica text and scholia, which now we have a critical edition, which consists of 17 volumes, it has many layers. So yes, the text dates from, we say it was issued around 900, but actually it consists of earlier writings. And the scholia, as I said, you have two categories. There are different dates. So when you see a legal source, I think it's important to know what exactly it is and from which period before you come to conclusions or observations. So it's a bit like an archaeologist digging into the different layers of the sources. So you have the Greek, the legal terminology, so you need Roman law, the different layers, and we still do not have good critical editions in Byzantine law, or sometimes we don't even have any edition at all. So there's a lot of work to be made there.
Yeah. So based on what you said, I'm going to take back what I said earlier in the following sense. The Greek is easy, but the words are often used with a technical sense that even if they're indigenous Greek words that you might look up in the dictionary and they mean this and this. So no, in a legal context, they might often mean something completely different. And so you have to know that, okay, I'm switching into legal jargon now.
Exactly.
Yeah. And even terms that you think you recognize, like if it's a Latin term, then you know that, okay, this has a technical legal sense and you look it up and that's actually easier than the deceptively Greek term that's actually, there's a Latin Roman meaning behind it. Yeah. So, okay. No, that's fair. It's more complicated than it seems. So how did Byzantine jurists or whoever used Roman law in Byzantium, say 11th, 12th century, how did they cope with these problems? Like, was it difficult for them to access it? Did they have like some sort of shortcuts or handbooks to help them?
Yeah, 11th century. When you say how did the Byzantines think that law is difficult? It really reminds me of the opening words of Psellos. The Psellos wrote a legal didactic poem, the Synopsis των Νόμων. So he wrote it for the future emperor. Who was it? Michael VII, I think, Ducas. So after the order of the emperor, he had to write. So the idea was, he said to Psellos, write a text that explaining law in a simple way, in an easy way for the future emperor. And Psellos begins the poem, and he wrote it in verses because probably it was easier to memorize. So Psellos begins by saying, oh, law is so difficult. Oh, law is so chaotic. Oh, law is so, difficult, but it is necessary, he says. So it was hard also to define what law is probably then. But yes, they had shortcuts. We spoke about the basilica. It was an enormous work. In fact, not everybody could possess the basilica. So after the basilica, you see that there are many works that derive from the basilica that either summarize it or it's a sort of tool to the basilica. So these works were used more often in practice. I think also there's, if I'm not mistaken, at some point, it's the Patriarch of Alexandria who asks Balsamon, the great canonist, he says to him, we know about the basilica, but we here in Alexandria, we don't have the books. Is that a problem? And Balsamon says, well, for people who live in the capital, there's no excuse because they can go and consult. But for people who are outside, you are excused from not knowing the basilica. So that's an interesting testimony on the application of the basilica, or how difficult it was to find, to go back to your question.
Yeah. Do we have a sense for how much Latin they may have known at that point? So legal experts in Constantinople in the 11th and 12th centuries, how much Latin would they have known?
Yeah, that's it. That's a question that really intrigues me. I wish I knew. I find it very interesting. And personally, I think from what I've read and some hints and speculations that probably Byzantine jurists, at least some of them, knew more Latin than we think. And the reason I say this has to do with some information of some sources that I've come across, and from work of colleagues that I've read. To give you an example, we said that, I think I mentioned that, in the middle of the 11th century, there's a revival of legal studies in Constantinople. the Emperor Constantine IX, the Monomachos, he founded a law school. In fact, there are many questions whether he actually founded a law school. What he did was he appointed Xiphilinus as the head of the law school in Constantinople. He appointed him as the nomophylax, the guardian of the laws. And Pselos was appointed the head of the philosophy school. So in this novel, by which Constantine IX, the Monomachos, appoints Xiphilinus, he says that the nomophylax should know both Greek and Latin. That's one indication. Another indication that I found in some sources is that we have some Byzantine jurists from this period, 11th century, that actually, I think from their writings, we can understand that they have actually consulted original Justinianic legislation, the digest. I don't want to tire you now with details, but you can see from the way some terms are formed that, for example, Xiphilinus, it seems that he actually had consulted the digest. I mean, this is, again, I can't say this with certainty, and I don't want to be, I'd like to be a bit reserved in this, but there are some hints. I think the whole problem or the whole issue is also related to libraries in Constantinople. We know that they kept important legal manuscripts. So they must have had manuscripts of the digest.
Yeah.
They were in Latin. Someone must have them read them. Okay, not everybody, but there must have been a circle that could understand, read Latin, I think. And again, I cannot be 100% sure, but there are some speculations and indications here and hints that I think. But there's work to be done here. Yeah.
Yes, I very much look forward to that. I heard you speak about that topic, and it's very intriguing because I think you're right. I mean, the libraries would have preserved a lot of Latin texts, and certainly the corpus would have been among them. But anyway, so let's stick with the jurists for a little while longer, or Byzantine commentators on the laws or legal scholars. Did they make any interesting or distinctive contributions to legal theory or to the development of Roman law and applying it to, new circumstances as they came up? I mean, just a few examples or one example would suffice just to give the audience a sense of how they were engaging with this material.
Yeah, since we're in the 11th century, so I'll stick a bit in the. Also, I'll refer to some material that I know I've researched. And a name that comes to mind is a jurist from the 12th century. His name was Agio Theodoritis, and he wrote Scholia on the Basilica. So I think we mentioned what the scholia are. So these are the new scholia, the ones written by the younger generation, 11th, 12th century. So Agio Theodoritis is a jurist. We don't know a lot about him, of the 12th century. And the reason I refer to him because he has written around 200 scholia on the Basilica, which are rather lengthy. So it's a good material to study. It's not one or two, it's 200, which are rather lengthy piece of scholion. And he discusses questions like, well, there's a lot about theft, damage to wrongful damage to property, liability issues. And from what I've seen, his scholia, well, you can see that he has a rather a high level of legal knowledge, and he is capable of also. He knows the Basilica, by the way, but he can also produce some theoretical
distinctions or
distinctions. Yeah, there are a lot of distinctions of him, but I think he has a high he has a high standard of legal knowledge, and I think that his scholia is definitely worth studying. I think they will be studied in the future. So that's one name, and a second name is no, not a name actually. It's the author of a work from the 11th century. The work is a treatise on. It's called the Meditatio de Nudis Pactis. So it's a treatise on mere agreements or bare agreements. A bare agreement in Roman law, pactum nudum, was an informal agreement for which you had no action, so you couldn't go to court. So the author of this treatise, again, it's a treatise of the 11th century, the author of this treatise makes an exposition of the theory of contracts. So that's a rather remarkable text, actually, which has been studied the last years by more scholars. So that's two works or two that I can think of from 11th to 12th century, but I'm sure there are more.
Yes, and we are a long way from, having studied these texts and their authors in a systematic way. I mean, just like you said, picking out an author, so reconstructing an author from the Scholia is difficult. I mean, Homer scholars haven't yet done it with the Scholia on Homer. We're a long way from doing it in Byzantine law, but it's very promising area of research. So once you reconstruct them and you see that there's a kind of coherence to the way they're thinking about things. And so this brings me to the question of, like, what should be the goals of the study of Byzantine law moving forward? Because there are a number of things that you can imagine the field doing. So one is editing the text, which is absolutely necessary for anything else to happen. We can trace the evolution of legal thinking, working again solely within the texts themselves. And a lot of legal scholarship does this. It's kind of like it operates in the kind of bubble of legal thinking, and without sort of relation necessarily to the society around it. But there is some scholarship that's looking at like the application of law as an instrument of governance or of resolving disputes, like on a practical level, right? And that gets you into all kinds of other sources, sort of non-legal sources that are talking about this. So is there anything else that should be added to that mix? And I think as we're moving forward, I think the emphasis is going to be more on the practical application of the law in kind of social life. But are there any other kinds of approaches that you would want to mention or comment on those? Where are we right now?
I think it really depends on who is we. I mean, every scholar has a different approach in what he wants to use Byzantine law for. I mean, there was this discussion between Byzantine legal historians and Byzantine historians.
Mm-hmm.
Do we need a new history of Byzantine law? A
Yeah.
legal historian is interested, as you said, in principle, in the development of a legal rule, of a legal concept. And as I said, Byzantine law can help us to better understand Roman law. So there are a lot of Romanists out there who want to use Byzantine law for that reason. But there are also legal historians who want to use Byzantine law in order to see the development of a whole concept throughout the Byzantine period. And there are historians who want to use Byzantine law for other reasons, to find out perhaps things about the society in a particular period, things about the administration. So personally, I'm very open to any way that you will research it. I'm also interested sometimes to see the dogmatic development of a rule, but I'm also open, and I have done this in my writings of understanding law, of using law, of cooperating also with other scholars from other disciplines and learning from them. So I'm rather open to this, how you use Byzantine law. But again, it's really about what you want to find out.
Yes. So I mentioned at the beginning your dissertation, and I think that is a good example of this, because you kind of performed a legal but also historical analysis on the treaties between Constantinople and the Italian cities, where you were doing both a legal analysis of their actual provisions, but also like situating them in the historical context and what did they mean for the people making these agreements. So I thought it was sort of exemplary in that way. I have I have a broader concern about the way that we study. So here's something that I've become sensitive to and that I think is a problematic approach. So and this is an approach among general historians, that the law, and we mean here the Roman law or Byzantine law or whatever, is this kind of abstract, esoteric body of knowledge that very few people knew and has very little relevance to the kind of day-to-day. It's like an imperial thing. And you know how recently it's increasingly studied as an aspect of imperial rhetoric. Like, yeah, this is just kind of the image that the emperor wanted to give or whatever. And that it's kind of removed from the day-to-day concerns of ordinary people. I actually think that is entirely wrong. Like in my study of the long Roman Empire, I think that social relations, economic relations, as close to the ground as you can get, were fundamentally structured by the concepts of this body of law. And you actually even find church fathers saying this. Like John Chrysostom is a very good example. I mean, he says that every time you have a relation of property, whether it's movable like goods or immovable like real estate, or a person like slavery, there are the whole thing is sustained by imperial law, right? And yet I read these studies like that of like village life in, it could be anything, it could be late antique Egypt, it could be 11th century Asia Minor, and they're like, well, the imperial authorities are distant and not really relevant, and people on the ground kind of worked it out on their own. And every time you get into the details, it's about property, it's about dowries, and they're working through those problems, which are the problems of village life, entirely through the concepts of Roman law. Like they would have no rights to anything if it weren't for that. Their family structures are according to that, and canon law also, which is the sort of ecclesiastical supplement. And so I think that general historians, like non-legal historians, need to pay a lot more attention to these sources. I think they were fundamental. That's just the impression I get.
Yeah, I have to say here that most, if you read most scholars, there is a problem with Byzantine law about its application. And you will see in modern scholarship, there's often a distinction between Byzantine law in books and Byzantine law in action. Byzantine law in books are, I think what they mean is we have a lot of laws, we have a lot of legal compilations, but where are they actually applied? The problem is that in Byzantine law, we don't have so many sources which reflect legal practice. We do have some sources, and again, there's work to be done there, and make critical additions and study them broadly. But there is a lack of jurisprudence. One great exception, because I don't want to be always pessimistic, and we said that we need critical additions. One big exception is the Pyra. It's a work it's dated from the middle of the 11th century, and it's a unique work because it consists of fragments of the legal decisions and verdicts of a judge, Romaios, of a high court judge in Constantinople. Romaios was his name, Eustathios Romaios, and this compilation was written by an admirer of Romaios. And recently, very recently, some months ago, after many, many years, the critical edition was issued by, more people worked on it, but it was Dieter Simon and Roderick Reinsch who completed it. So it's not just a critical edition. There's also a German translation and a German commentary and elaborated indexes. So I think that this work, the Pyra, is really a unique work, and I think the critical edition of Simon and Reinsch will bring, it's certainly worth going back to the material of the Pyra and studying it again, because then we'll be able to make sound conclusions now that we have a good edition.
Yes, 1,200 pages.
Yes, but there's also indexes. Yeah. So you.
Yes.
Yeah.
And lots of German. Okay.
Yeah. That's yeah.
I've used it. It's extraordinary. And
Yeah.
the preliminary studies that we have of him is that he was actually following the laws pretty closely, and even when he was deviating from their provisions, he was clearly aware of what they were and has a reason for why he's doing that. But so that text is, let's put it on the optimistic side of how much the law was actually used in application by judges. My position is that this runs a lot deeper. In fact, I think the entire structure of East Roman society has a legal scaffold. I talk about this a little bit in the history, but the social orders or social classes in Byzantium are largely legally defined. Like, what is a senator? What is a soldier? What is a registered farmer? What is even a priest or whatever? Those are legal categories. And what's fascinating to me is that you never find social classes in the non-legal sources that are different from the ones that you find in the legal sources. Like they match. And there's some very few exceptions that are quickly normalized. Like, for example, monks and ascetics. In the early, like 4th century, 4th and early 5th century, you have asceticism and you have monks. So these are people doing something outside the social order, and there's no legal framework for them until they made one after the 5th century, and they're kind of normalized and regularized through canon law mostly. But anyway, okay, I'm digressing on my own things, but I came to appreciate just how important Roman law is for just understanding the basic history here. And I hope that's taken up by more historians of Byzantium. But what about Western historians? And because you've made the case that Western scholars should be looking more at Byzantine materials. You mentioned earlier some cases where the comparative study would be, fruitful. Are there any other arguments that you want to make here just for why Western historians should pay more attention to our material?
Well, as I said, I find strange that Justinian is being mentioned in all the books, and they don't say he was Byzantine, for example. Yeah. But I think what I said, I'll stick to what I said about the comparison between, especially because the 11th, 12th century is the rediscovery of Roman law. It's certainly worth making comparisons between both materials because they both have a common base. But, well, even after, I have to say, you have the humanists who also used Byzantine legal texts. But my main complaint or observation here is that I haven't seen in any book discussing European legal history something more about what happened in the East in this empire that lasted more than 1,000 years. It's skipped.
Yeah,
that was the idea. I don't have anything else, I think.
And hopefully your handbook will make this material much more accessible too for them. I mean, that's also necessary. By the way, like the main surveys of the best ones, the surveys of Byzantine law are in German and modern Greek.
Yeah, yes, it's true. And there've been some, the last years, there've been some books, some English books as well. But yeah, this is our book, the book by Roos, Meijering and myself. I think it's the first English book which actually discusses a wide range of sources with an English translation. So the idea, as I said, was it's based on our teaching. So the idea is to explain law like Pselos did. It's not in verses, but in an easy and simple way to the audience. That's why there are also we try to use some, you will see that the language is very simple, and we do not use footnotes, for example, but there are very few footnotes, but at the end of every section or every chapter, there's bibliography if you're interested to continue reading. There are a lot of schematic approaches also that can help the student or anyone who's reading the book to better understand actually what do these Byzantine legal sources look like and how are they related to each other. That was the idea, because I have to say we have a very important book by Spiros Troianos, which is in Greek and translated in German as well, the Sources of Byzantine Law, which it's a kind of Bible of Byzantine law.
Very
but
good
our
book.
book is a very, very different sort.
Yeah, but they're complementary.
Yeah, they're complementary. Yeah.
Yeah. I've relied on that book a lot. It's very useful. And there are all of these little weird sources, around, like we have the major, planets like the Basilica and so on. But then there are all these little weird satellite texts. Like there's this 11th century, it's just a few pages. It's a history of Roman law, like from the time of the kings and the Republic. And Adeliates also wrote his sort of, it's like a handbook of Roman law with a history from the Republic, and they're in Greek, and I just find them fascinating texts. If those kinds of texts were written at that time in the West, there would be like so much bibliography about them.
Yes, exactly. That's what I'm trying to say. I mean, the relevant glosse, the comments of the glossators, we call them. These are the civilians, well, the people who rediscovered the digest and wrote comments have been studied in detail. Whereas we still don't know. We still don't know who wrote them, how many they are, and we still don't have editions, critical editions about, or translations. That's another problem of Byzantine law, to go back, that it is in Greek and there are no translations, even of the Basilica. So I think if works were translated, they would be used, of course, by more scholars.
So where do you see the state of the field right now? So when I was in grad school, there was a fairly robust group of scholars who were working on these texts and were producing a lot of good work, but now they're mostly retired or deceased and so on. Is there a next wave of scholars coming up? What do you see happening?
I think there was never a big audience for Byzantine law. It was always modest. But we do have, well, first of all, Byzantine law is being taught in Greece, in the universities, at the law departments of Athens, Thessaloniki, and Komotini. So there's big tradition there. In Groningen, we do our best to continue this tradition in research and teaching. And the Sourcebook is a testimony for that. You have in Germany, Mainz is very active. In Italy, of course, because Roman law is always there's always an interest of Byzantine law because of Roman law there. But I see there are more. I mean, in the last year, I've also been. I see that historians reach out to us. I refer to Groningen because this is where I work. There are historians who deal with some Byzantine legal sources, and they come to us and help, and they want some help in what is this text exactly. So we had a cooperation with France, with Sorbonne, and now with Germany, Hamburg. These are not legal historians. These are historians who deal with some Byzantine legal texts and want our expertise. So we help them in that, and we learn from their discipline as well. I'm optimistic in the sense I see that there's also an interest in canon law. That's also the last years, there have been some new recent editions and books about canon law, Byzantine canon law, Southern Italy, and more. So I'm not. I hope the Sourcebook will raise some interest, and I'm not pessimistic, but it's maybe you don't have the big names, as you said, because I refer to Groningen, the Basilica. The critical edition was made in Groningen by Scheltema, who founded also the School of Byzantine Law in Groningen. That was one school. Another important school was in Frankfurt with a Max Planck für Rechtsgeschichte that was directed by Dieter Simon and cooperated with Athens as well. So they've also produced many important Byzantine legal texts. Well, it's a pity that
Yeah.
Max Planck stopped, but okay. There are also some German scholars or scholars in Germany who continue somehow this tradition.
Yes. Yeah, I'm optimistic also. And I think we should not look for, like, I think that the era of the big names has passed, not because the work that like we do, like our generation does, is not is good or anything. It's just that we're just living in a very different institutional and social environment where big names are just not what our fields are producing. And I think generally that's a good thing. At any rate, I mean, I have a lot of misgivings about the system that produced big names. Let's do the work, and I don't want to see that system come back necessarily. But be that as it may. So we're almost out of time. Any final thoughts, or like what's next for you? What are you doing next, or anything else?
I'm now going out with my friends. That's what's next. But
Fair enough.
I'm starting to teach, but a subject that I'm interested in, I think the following year would be Byzantine justice. I want to have a look also because we have now this edition, as I said, of
Right.
Paira. It's worth going back to this material, even if it is in German, even if it's so many pages, to, understand these cases better. And perhaps more works from jurisprudence that could actually tell us was law applied or not and how. So I'm more interested in this concept and application of Byzantine justice. That's subject for the following year.
It's such a rich area, and I'm often struck by, I don't know how to put it, the humanity that is sometimes expressed in the verdicts here. And I don't
Oh
know
yeah.
how I don't know how well it corresponds to reality, but they're definitely trying to be compassionate and understanding to the people who come before their courts with these incredible life stories.
Yeah.
Anyway, it's a wonderful resource. So yes,
Yeah.
I very much look
If,
forward to that.
well, thank you for the invitation. And I would say, as they're saying, Byzantine law for all.
Yes, the one law for all. Yes. Thank you, Daphne, so much for coming on. And it's been a pleasure to read your work and use
Thank you,
it. So
Anthony.
I'm very grateful for that.
Yeah. And good
So
luck with all the podcasts. And
thank you.
yeah.
I intend to continue. All right.
Okay.
Take care.